You all know how much I value intellectual property, copyrights, trademarks, patents. They're super powerful, super valuable. There's one thing that's even more powerful and more valuable, and that's contracts. Because contracts can create rights that don't exist, and contracts can kill rights that did exist. It really matters what you sign. It really matters what the contract says, because once you've signed it and you've given away your rights or you acquired some rights, everything changes. It doesn't matter who originally owned it. It doesn't matter what the law says. What matters is what does the contract says. And in a moment, you'll know exactly what I'm talking about. My name is Andrei Mincov. I'm the founder of Trademark Factory. And in this video, I'm going to share my thoughts about yet another intellectual property dispute. This time around, it's a bunch of companies fighting each other over the rights to Ms. Pac-Man. All right, let me start by reading from the article and we'll go from there. Strange tale of an arcade legend's ownership takes another turn. AtGames, the makers of throwback mini consoles and arcade cabinets, has acquired an interest in the nearly 40-year-old Ms. Pac-Man intellectual property, roughly a week after Bandai Namco sued the company and alleged AtGames had interfered in negotiations to shore up a tangled rights issue. A representative of General Computer Corporation, GCC, the company of college kid developers who first programmed Ms. Pac-Man in 1882 and later sold the creation to Bally, Midway, and Namco, confirmed to Polygon that the transaction had taken place. AtGames acquired the royalty interest owed to GCC's 7 right holders, effectively the right to be paid whenever the Ms. Pac-Man work is used commercially. The deal was consummated sometime in August. Now, the wording here is crucial, and I understand it's an article, it's an interpretation of what somebody said, but let's take it for face value. If that's exactly what they bought, notice what it says. It says that they bought the royalty interest owed to GCC's 7 rights holders. Okay? We're going to get back to that in a moment, but let's keep going. As part of our ongoing initiative to the caretakers of important cultural touchstones, we're privileged to gain these valuable rights pertaining to the iconic Ms. Pac-Man arcade game. Bing Zhong, the chief executive of AtGames, said in a statement put out this morning. AtGames, known for its line of Flashback and Flashback Blast plug-and-play retro gaming devices, announced the transaction early this morning. It follows the federal lawsuit from Bandai Namco alleging that AtGames misrepresented itself as licensed to make Ms. Pac-Man products and created or even distributed Ms. Pac-Man mini cabinets under those claims. AtGames representatives declined further comment to Polygon, but did provide a copy of their attorney's response to Bandai Namco's counsel. The letter calls Bandai Namco's actions another transparent effort to punish AtGames for entering into its August 2019 agreement with the GCC individuals, to sully AtGames' reputation, to disrupt AtGames' business relationships, and to artificially manufacture leverage in the ongoing negotiations between the parties. Now, to wit, Bandai Namco Entertainment America is so irritated by the fact that AtGames has entered into a contract with the GCC individuals, an arrangement that Bandai hoped to exploit for its own benefit through deceit and bad faith, that it has ordered its lawyers to attack AtGames by any means possible, AtGames lawyer wrote. Now, as if lawyers and courts have never been before used for business purposes, right? Lawyers is just a tool. Law is just a tool. It's a tool in your competitive battle. It's a tool that can give you competitive advantage, or it's a tool that can be used against you. to deprive you of that competitive advantage. So even if that's true, not the first time, not the last time. Let's keep going. Reached by Polygon on Thursday afternoon, Bandai Namco of America representative noted that the company does not ordinarily comment on pending litigation. However, this time around, the company did comment to underline the nature of the rights AtGames bought and the ones Bandai has and controls. And that is crucial. So Bandai has exclusive rights to the use of Ms. Pac-Man mark and to reproduce, distribute, display, perform, create derivative works, and or use the Ms. Pac-Man copyrights, the statement said, as well as to enforce the Ms. Pac-Man mark and Ms. Pac-Man copyrights in the United States. So first of all, the difference, copyright and trademarks. Trademarks protect the name, right? If you own the trademark on Ms. Pac-Man, or you have an exclusive license that you can enforce, that allows you to stop anybody else from using that name in connection with similar products, right? So they can have games, but they can't call them Ms. Pac-Man because that's what trademark does. Copyright is totally different. Copyright protects the code. Copyright protects the software. Copyright protects the designs. Copyright protects the images. Copyright protects the videos. So the content, the multimedia content, the script, that sort of thing, not the name itself. So what they're saying is that they have both the trademark and the copyright. So if that's true, what the hell did AtGames buy? Well, we're going to get there in a second. AtGames has not acquired any control over the Ms. Pac-Man intellectual property, merely the right to be paid royalties when it is used in commercial works. That is a massively important distinction that you must understand because intellectual property, both copyright, trademarks, patents, any intellectual property is a bundle of rights, right? It's not just one right, it's a collection of different sub-rights. But these sub-rights can be split into two big categories. The first category is the right to do something with that intellectual property and prevent others from doing it. That's the first one. That's your right to control the use of the work, right? It's your ability to give out licenses. It's your ability to sue people who use your works without license. It's the right for you to go to court and prevent such use. That is the right to control the use. And that right is totally separate from the right to get paid. It always makes me laugh when, when I have two parties who are trying to come up with an agreement between the two of them, and they say, well, let's come up with a solution about co-ownership of intellectual property. I will own 75% and you'll own 25%. This makes no sense from the control perspective, because you can't control the use of 75% or 25%, right? You can only control 100. So if you control 75 and the other party controls 25, you still need their consent. However, you can use that breakdown in terms of who gets paid what. So if the IP that you own collectively or jointly, if it generates $1,000 and you own 75%, then you get paid $750. Whereas your partner is going to get $250, right? But again, the ownership, the control is joint, unless the agreement states that, let's say, partner A has the right to give out licenses without asking partner B. And all they're doing is they're splitting the revenue. Either way, conceptually, these are two completely different things. The right to control and the right to get paid. Now, I hope you got it, because this is crucial in this dispute, and really this is crucial for your business if you run one. Because when you sign an agreement, if you don't understand exactly what you're signing, you can find yourself in the situation when what you bought is not exactly what you thought you're buying, as what it looks like AtGames may soon discover. Let's keep going. The position stems from the complicated way in which Ms. Pac-Man was developed. 3 programmers, then students at the Massachusetts Institute of Technology, developed a mod for Namco's Pac-Man that eventually became Ms. Pac-Man after they shipped it. I don't think they shopped it. I think they shipped it to Bali Midway, then the rights holder in the US for Pac-Man products. Over the years, Namco and its descendant companies acquired full control over Ms. Pac-Man. But even after agreements reached in 1983 and 2008 with the 7 individuals connected to GCC's stake in the IP, some royalty rights and obligations were still unresolved. Bandai Namco, in its lawsuit, says it had been in discussions with the GCC successors in interest about a once-and-for-all deal over Ms. Pac-Man, and that AtGames meddling had tanked those negotiations. The lawsuit points to a mini Ms. Pac-Man cabinet it says AtGames made without permission, insinuating the company was making an offering for sale unlicensed products. AtGames' position is that it was a mock-up device privately shown to someone who isn't a consumer, right? So someone from GCC. The intrigue over Ms. Pac-Man is one half of the case Bandai Namco presents in its allegations of false advertising, unfair competition, and copyright infringement. The other claims concern a plug-and-play Pac-Man flashback blast device whose commercial launch in 2018, Bandai Namco alleges contained code it hadn't been not approved. Specifically, the game was a port of the Nintendo Entertainment System version, not the arcade game ROM. The unit sold poorly, with many reviewers alleging that they had been mislaid by the review unit that AtGames provided, which had the more desirable arcade ROM. So you can read the decision. And what this really makes me think about is the story that I read in Ryan Holiday's book, The Obstacle is the Way. So he talks about the story about 2 American companies who wanted to acquire rights to a piece of land to sell bananas, to sell fruit. And one of these companies was a massive, super rich with very deep pockets company. And the other one was this entrepreneurial, small, agile company with very few resources. The problem was, so they both wanted the same piece of land because it was so well positioned that owning it would make them a lot of money. The problem was there was no clarity as to who owned the land. And so the big company, the company with deep pockets, hired an army of lawyers who were writing memos after memos, trying to come up with the right summary, with the right conclusion about who owns the land. And they analyzed titles, they did all sorts of different things. And meanwhile, the agile entrepreneur, he did something brilliant. He went to both parties who claimed that they owned the land, right? So there was a dispute between two companies there who each said, we own this. And so instead of trying to figure out which of them is correct, which of them really owns the land, what he did is he bought it from both, right? So one of the contracts was naturally just an empty shell, right? Because the purchase was over something that the party didn't own. But it didn't matter, because as long as he had commitments from both, that meant that as a result of that, he became the owner of the land, right? So meanwhile, the company with deep pockets, all they ended up owning was a memo from lawyers. This illustrates 2 different approaches to contracts. And I've always followed the one of these approaches, the latter approach. This example with buying the land is a great illustration of that. And it looks like, in this case with AtGames, everyone is trying to follow the former approach, which rarely works. So the 2 approaches are this. The first approach is where you build a contract based on where everyone is today, right? Especially in disputes, it's just a really bad starting point, because you start with the two parties or more than two parties hating each other and trying to figure out who owns what and when and why and what who did and how bad it was, and how much they hurt each other, and all sorts of crap that's absolutely irrelevant if the parties actually want to come to a solution, right? Because this is about describing the problem and trying to solve the issue based on the problem. And the second approach, the one that I always advocate, is where do you want to end up, right? When I used to be a lawyer and I used to do disputes and do all sorts of things, that was before I gave up my license in Canada to be able to deliver the guaranteed trademarking services that we deliver now around the world, which I couldn't do using my old Canadian license. So when I was still lawyering, so that somebody would come to me and they would share their story, and one of the first questions I would ask is, what are you trying to accomplish? Where, in the perfect scenario, what do you want to happen as a result of me helping you? You told me a very compelling story, very touching. You didn't come here to cry on my shoulder. What exactly would happen in the perfect world? You want some money, you want them to stop doing certain things, you want them to say they're sorry, you want them to kill themselves. What exactly do you want to accomplish? Once we understand what they're trying to accomplish, then we have a conversation with the other side, and now we're trying to figure out what they're trying to accomplish. And then we're trying to see if there's any way to accomplish something that would work for both parties, right? Is there an outcome that both parties would be okay with? And what often happens is the other side always starts like, well, your guy did this, your guy did that. I said, it doesn't matter what they did. It doesn't matter. What matters is, what is it that we're trying to build as a result of this agreement? Let's figure out if there's something we can agree to. And if yes, then we're going to build a contract based on where we want to end up rather than where we are today. Because if there's agreement as to where we want to end up, where we are today doesn't really matter. And to the extent that it does matter, it's easy to address. So with this particular dispute around the ownership, they're doing something that doesn't make a lot of sense, because they keep fighting and they keep trying to figure out who owns what. Instead, if it's really so valuable, what they should do is what the agile entrepreneur did to acquire the piece of land. Lock everyone in one room, everyone who touched the rights at some point, and just buy them outright, and make them an offer that they can't refuse, and just be done with it. And of course, you have to be very, very, very careful about understanding exactly what you're buying, because, as I already mentioned, just buying an interest in the royalties gives you no rights to control, and more importantly, it doesn't give you any rights to even use that IP on your own. All you can, all it gives you is the right to be paid when somebody else uses it on somebody else's permission. So I hope it was a good lesson. I hope you learned something useful, something interesting. If you did, like this video, subscribe to this channel. We post a new video every single day. And make sure you post a comment below. Let me know your thoughts about it, right? I'm curious what you like about my videos, what you don't like about my videos, because we're growing this channel. We're not stopping. And I want to make sure that the videos that I put out there, they resonate with you and that you're getting value. So, like I said, like, comment, subscribe, and we'll take it from there. I'll see you in the next video.